I'm Brian Dunklin. George, you there?
Yeah, I'm George Roddy.
And I'm Tim Herridge.
Thank you all for joining us for the webinar, trying to give an update of House Bill 8. Hopefully, Dunklin, my email contact information should be on the screen, as is my website. And this is presented in conjunction with George Roddy and Tim Herridge and FlipThatContract.com. Appreciate you guys inviting me for an opportunity to address this issue tonight. I've very quickly listed my credentials for those of you who aren't familiar with me, but the long and the short of it is I've been practicing law for 30 years and was on the faculty at SMU for about 23 years. And I regularly give speeches to the Advanced Real Estate Law course or to other Dallas and Texas Bar Association real estate courses. I've listed a few of them here. But I'm going to move on very quickly to the text of the bill and start talking about the issues. I have to have my typical disclaimer. The law is constantly changing, and so these materials are for general educational purposes only, and no attorney-client relationship is established by the presentation of these materials, and you're advised to consult an attorney with respect to your specific circumstances. HB 8 came out of the 82nd Texas Legislature, 5,672 bills that were filed in the general session. 1,410 of them went to the governor. The last day for the governor to sign or to veto was yesterday, June 19th. He did not, in fact, veto HB 8. If you Google the governor's website, you can see the bills that he did veto, and there's a brief explanation of what his thought processes were in that veto process. HB 8 was originally offered by Drew Darby, a Republican from San Angelo, and this is on the heels of some history that we have with respect to this particular issue. I was blessed today to have the opportunity to speak to his chief of staff, who is Trent Thomas, and he was in Austin, and I caught him to confirm some information that I had believed was true. But the long and the short of it is he had an opportunity to give me some insights into this bill, both its history, its background, the legislative intent, and most importantly, to address the issues that I think are of interest to this audience, specifically whether or not this bill would impact our ability to assign a contract as a wholesaler, or as someone who wants to tie up a piece of property and then assign the contract to someone else to close it. This particular statute repeals Texas Property Code Section 5.17 that was passed in previous legislative sessions, and it adds a new subchapter G to chapter 5 of the Property Code, and that's where you can find it. Let's get specifically to the details of the bill, though. The title of the bill is Certain Private Transfer Fees Prohibited. And on its face, when we start going through the definitions and specifics of this bill, it's going to look like there are going to be issues that will present problems to those who want to put a property under contract and then assign the contract. A little bit of a background and history on this bill that I think is important for understanding what's going on. There was a company in Texas that had a unique and interesting concept. It would approach real estate developers and suggest to them that there was a way for them to generate some additional money, i.e. that every time a property in that particular development or condo regime changed hands, that there would be a transfer fee that would be paid that would go back to the original developer. And the theory was very novel and very interesting. The gentleman who I understand was involved in this was a gentleman named Joe Alderman, and he was out of Round Rock, and his company was called Freehold Licensing. and his concept was that if developers used his plan, that they would have a source of revenues down the road as properties transferred hands, as essentially which required, if they were required to comply with the covenants or deed restrictions that were contained in a filed declaration that would impose this duty on all the properties that were being subsequently sold. But as you can imagine, there was a resistance to this process for the purpose that consumers down the road wouldn't necessarily enjoy having to pay these fees or even be aware that they were going to be forthcoming until they were hit and charged with at the closing. Now, some of this research that I'm talking about was generated by the House Research Organization and its bill analysis back on May the 2nd. But the long and the short of it is HB 8 has a certain limit. Well, the title of it is Certain Private Transfer Fees Obligations Are Void. And I'm concerned that maybe everybody's going to be able to see all of the PowerPoint presentation, the language that may be covered up on the side. So I'll have to move my...
Brian, everyone can see perfectly fine.
Okay, good. They can see it uninterrupted. Okay, mine, I'm not seeing it as well because but thank you. That's what I needed to know. The HB 8 starts off by having this statement that is the principal command of the statute. It says, except as provided by this subchapter, a private transfer fee obligation created on or after the effective date of this subchapter is not binding or enforceable against a subsequent owner or subsequent purchaser of an interest in real property and is void. So that's the basic concept, that a private transfer fee obligation created after the effective date is not going to be binding or enforceable and against a subsequent owner or subsequent purchaser and is void. That's the first basic concept. But now we got to get in the definitions. What does that mean? Well, what that means depends upon some of the terms that were used. So we got to start with the word transfer. Transfer means, according to the statute, the sale, gift, conveyance, and then here's the word assignment, inheritance, or other transfer of an ownership interest in real property. Well, many of us who are familiar with the process of using a contract to tie up a piece of property would understand the notion that you have an interest in real property when you have it under contract. You have an equitable interest. You don't own the property, but you have an equitable interest in the property by virtue of your contract. So technically, the transfer term identified here means any kind of an assignment or transfer of an ownership interest in real property. And so now we've got reason to be concerned because it seems to be talking about what we, in fact, do on a regular basis, i.e. assign contracts. The next definition we have to think about is what's a private transfer fee. And a private transfer fee means, in the statute, an amount of money regardless of the method of determining the amount that is payable on the transfer of an interest in real property or is payable for a right to make or accept a transfer. So here again we got something to be concerned about. It looks like the statute may be applying to the charging of an assignment fee because it's payable on the transfer of an interest, i.e. when you assign the real property, or it's payable for a right to make or accept that transfer. That would typically be payable to the person who has the property under contract. And the statute refers to somebody who it calls a payee, who is the person that receives this transfer fee. All right, let's move to the next issue. Again, so far, HB 8 looks as though it may create a problem if it's going to prohibit a private transfer fee. The next term is what is a private transfer fee obligation, and it means a private transfer fee or an obligation to pay a private transfer fee created under a declaration or covenant recorded in the real property records. Well, this is what I think the statute was trying to focus on, that if you were going to charge a fee in connection with an obligation that was created under a declaration or something that was going to run with the land and be perpetual, or at least run for 99 years, which was the typical arrangement in the declarations that charge these private transfer fees. So that's what I think the statute intended to focus, but by the language in the second part of the statute, it would also apply to a recorded or unrecorded contractual agreement or promise. So this, again, appears to look as though it's going to cover our typical contract that we've created and that we then wish to assign for a fee. And here again, it looks like HB 8 is creating a problem for us. Let's go to the next slide. Then there's the definition of what is a subsequent owner. And the language that's used means a person who acquires real property by transfer from a person other than the person who is the seller of the property on the date the private transfer fee obligation is created. So this looks like it could apply to the assignee from the wholesaler, because it could be considered, that person could be considered a subsequent owner, a person who acquires real property by transfer from a person other than the person who is the seller of the property. Now, some of us would look at that and say, well, wait a minute, I'm selling my equitable interest by signing the contract, so I am the seller. But nevertheless, this language, I think, created some confusion as that, because it makes reference, as it does, to a person who's acquiring real property by transfer from a person other than the person who is, quote, the seller. It doesn't say who is the record owner. It says who's the seller. But this other definition is also problematical. It's all virtually the same. A subsequent purchaser is a person who purchases real property from a person other than the person who is the seller on the date that the private transfer fee obligation is created. So long and short of it is all of these terms combined initially appear to look like it's going to create at least an impediment to assigning a contract. But if we go further, I think we then start to find more information that is of benefit to the wholesaler and gives us some comfort. And here's where, when I visited with Trent Thomas, the Chief of Staff for Representative Darby, he gave me confirmation that this is the focus of the legislative intent of this statute is not to prevent parties from assigning their contracts, but instead to prevent multiple charges down the road against subsequent purchasers and owners. And here's the key language that I think gives us some real comfort. It goes on to say what is not a private transfer fee obligation, and it specifically says that it is not consideration paid by a purchaser to a seller for an interest in real property transferred. And again, our position is going to be that someone who has a property under contract is in fact the owner of an equitable interest, and if he's being paid consideration for his sale of that equitable interest, this appears to be carve out that situation. It goes on to clarify it, however, though, it includes additional consideration paid to a seller for the property sale after the interest in the property has been transferred to the purchaser if the additional consideration is paid only once, and if that payment does not bind successors in interest to the property to any private transfer fee obligation. Here, I think it's much more clear that the wholesalers who are attempting to assign their contracts, it's intended to hit developers who are seeking to get multiple charges from subsequent owners down the road. Now, there's other language, but to me, this is the critical paragraph right here. This was the discussion I had with Trent Thomas today. He's also heard, as you can well imagine, from the Texas Association of Realtors, from the Texas Land Title Association, from Stewart Title, from other investor groups who have been concerned about the perhaps unintended consequences of this statute. And he has at least given me the comfort that this particular provision should shed some light on the legislative intent. It goes on to say that a private transfer fee obligation is not a payment to a lessor under a lease, including a fee for a consent to an assignment or a sublease or a transfer of a lease. This sounds an awful lot like our assignment of a contract. And then finally, perhaps even additional comfort, what is not a private transfer fee obligation, consideration paid to the holder of an option to purchase an interest in property. Many of us who counsel wholesalers recommend to those wholesalers that they alter the contract to limit the remedy of the seller to the retention of the earnest money. And to do that on a TREC contract form, you can go to the default provision on paragraph 15 and just strike through the entire second line and eliminate the seller's remedy to sue the buyer for specific performance or for damages. And if you do that, that means that the seller's sole remedy is the retention of the earnest money. Now, it's not intuitive for a minute, but if you think about it, if you've limited the remedy of a seller to the retention of the earnest money, you've converted that contract into an option contract. Now the buyer is in a position where he can buy or not buy. All he has to lose is his earnest money, and that means he's got a sum of money that he loses if he doesn't buy, but he can't lose anything more than that money. Well, that's what we call an option, where you have the right to buy and can compel the seller to sell, but you're not obligated to buy, and if you don't buy, all you lose is the sum of money, i.e. your option fee. Now, this is different than the option fee that we see in paragraph, is it 22 or 23 of the TREC contract forms, where you have an option to terminate. This is by altering the TREC contract form to limit the remedy of the seller to just the earnest money. But here again, it appears that it would not be a private transfer fee obligation to get paid a consideration to the holder of an option to purchase an interest in the property. So I think these particular provisions of the statute that define what is not a private transfer fee obligation is what gives us the most comfort. That's basically all I have for my presentation. I imagine we may have some questions or some other comments.
Folks, I'm getting ready to, we're going to open this up to Q&A, and so if you would, there's a question screen on your panel. I would really like you to either go to the question screen, or where it has your name as an attendee, you can click on raise hand, and if we see anyone raise hands, I'll unmute you and you can ask Brian your question, or you can chat it down in the bottom of the screen, and we can answer it there. So
Brian, hey, Tim, can you hear me? Brian, Tim, can you hear me? It's George.
Yes, go ahead, George.
So how long was your conversation with the Chief of Staff? I mean, tell me how that conversation went. Was he pretty emphatic once you mentioned
He actually went into some considerable depth about what the real problem was in terms of addressing the issues that have been raised in the past by this pattern of encumbering property with the obligation to make future payments. And he indicated to me that there are actually federal rules that are pending that will probably be finalized in the next 45 days that virtually mirror the same concept, but at the federal level. And so, yes, he, I think, was very emphatic that this was not intended to disrupt commerce by preventing the assignment of contracts or the profitable assignment of a contract, and quite the contrary, was intended to prevent multiple charges. And that's why I like this language back in the statute that relates to the ability to defining that if it's only paid once,
Right.
and if it's not binding on successors and interest to the property, then now that's not what an assignment fee is in a contract. Ours is only paid once, and that payment doesn't bind successors and interest to a subsequent private transfer fee obligation. So he was, I think, very clear that this was not the legislative intent to hinder the ability to assign a contract, but rather to nail down this other issue.
Brian, Joe Snow has a question. He said, is it likely there would be additional legislation to specifically clarify this law that it isn't applicable to assignment contracts?
Well, it's always possible. I would be surprised. Obviously, we've got to by any legislature, it'll be another 2 years before we see them again. But so I wouldn't really anticipate anything coming down the road unless there's some court cases that create difficulty. And I would expect, particularly in light of the legislative intents that Trent Thomas tells me was part of Representative Darby's thinking in proposing this legislation and its legislative history, that we're not going to need that clarification.
Gotcha. So, after talking to them and if you were somebody just getting into the business and your confidence in representing me or someone else in court, tell me, do you feel like you have a good case, or do you think it would even go to court?
No, I don't believe this is an issue that will ultimately go to court. Not only do I think it's nice to hear Trent Thomas say what he said, but where we're always going to start as lawyers is with the express language of the statute. And I think the express language of the statute makes it pretty clear that what we're talking about doing, getting paid for assigning a contract to someone else who's going to close it, where it's only paid once and where that payment doesn't bind a successor and interest to the property to any subsequent private transfer fee obligation. I think that language is amazingly clear. And if it were brought up in court, to me it would be a fairly easy matter for a court to decide that by summary judgment that the law did not impose did not void. Think about it where it would normally come up too. Is the assignee of the contract going to raise this issue? The only way they perhaps might do that is to get an assignment of the contract and then not want to pay the assignment fee. Well, frequently the assignment, the payment of the fee comes when the contract is assigned. It may also come when the transaction's closed, but if they want to close the transaction, they're going to have to get the benefit of the assignment. I don't think they want it's the fee that's supposedly void. But how many assignees of a contract dealing with wholesalers are then going to turn around and deprive the person who's brought them the contract of the fee that's been agreed upon? And it could happen, but it won't very likely happen more than once to that same wholesaler. He's not going to sell another property to that buyer.
Hey, Brian.
If he's not going to get paid. Yeah.
There's another question. It says, would this legislation apply to a mortgage assignment or AMPS or IMAPS type transaction? Since these deals would seem to mimic the typical wholesale deal, it seems as though this legislation would not impact these either, i.e., a one-time payment, and you could make them an option as well.
Well, that gets into a more complicated question to define exactly what the underlying transaction is. But based upon the way the question was phrased, if there's only a one-time fee and if it's designed as an option, then presumably the statute wouldn't create problems for that transaction as well. Again, that's not the purpose of this transaction, of this legislation. It was to close loopholes and make clear the exemptions involved in this situation. Here's what's really going on. Some of the principals who wanted to run around this statute that was passed in the 2009 state legislature went out and formed nonprofit organizations. Okay. The whole point is that as long as you're taking these fees from a development and you're benefiting the properties, then fees aren't going to be disallowed. But what they were trying to prevent was somebody setting up a charge that would go forward as many as 99 years and then trying to sell that income stream on Wall Street. And it was happening, but it just didn't represent a fair, there was no real consideration for that subsequent transfer if the monies that were being paid didn't ultimately go to somehow benefit the property. That's not at all what we're talking about with the assignment of a contract. There's a beneficial interest, equitable title that's being transferred, and you're only paying for it once, and that payment doesn't bind successors in interest of the property to any subsequent transfer fee, private transfer fee obligation.
Right. We've got another one. Let's see. It says, so will it be legal to do, illegal to do, or illegal to do when a wholesaler has a contract with the seller and wants to assign it?
Well, I think that's what we've been talking about. The answer is it should be perfectly legal for a wholesaler to assign his contract.
Let's
Brian,
see.
and Brian, you'd feel comfortable, you don't think there's going to be any ramifications after talking to Trent Thomas, after researching it. Your position is it's status quo. If you guys are doing it the right way and no funny business, hey, stay on target, and we're still open for business.
Well, I think we're open for business now. All I've addressed is whether or not this statute creates problems for somebody who's a wholesaler. There are lots and lots of other issues. Wholesalers can create all kinds of problems depending upon how they assign their contract, what their contract, the underlying contract looks like, what it says. Those are completely different issues. But this statute, I think, will have no effect on the ability of wholesalers to assign their contracts.
All right.
So the next question is,
what else, Tim?
Is how will the next guy down the road know how to interpret what it is not, since clarification could be 2 years away? They've seen other investors just state that we have to double close instead. So I guess the question is, of course, there's always going to be multiple opinions. Otherwise, you would only need one attorney per city. This question is saying they're hearing other people saying that you're just going to have to double close and you can't do assignments. I mean, what would your response be to that, Brian?
I'd say read the statute. And if you read the statute and you look at the language that's specific, this statute doesn't affect an assignment of a contract. If you're looking, there may be other issues, as I say, that could impact it, but this statute, in my opinion, all you're getting is my opinion. And my opinion is based upon having read the statute and having used common sense meaning of the language, and confirming that by having talked to the chief of staff of the author of the statute that is telling me what the legislative intent is. Now, that doesn't mean that there can't be other opinions, but I would like to say to the person who would have another opinion, answer my response is read the statute and this language. How does this language not address the problem that they're claiming now exists? And I will say that where I've seen these other opinions, they haven't quoted this language. I don't know if they didn't look far enough, they didn't understand it, and that doesn't mean, what's the old joke? The last time I was wrong was the last time I thought I was wrong. But if my opinion isn't correct, how do we explain this language that I'm showing on the screen?
Okay. Let's see. Any more questions out there? I think we got to all the questions. Folks, I really appreciate you answering these polls. Helps George and myself just kind of get a good gauge on the content that we're providing, and help our presenters like Brian just help us make sure we're delivering good content. So I really appreciate the help answering these polls. George, you got any closing I mean, look, Brian, you got anything else? I mean, it seems like the questions are dying out here.
No, I think I've said what I've had to say. I would just sound redundant to say it again.
Okay, well, guys, I really appreciate you showing up. And for those of you that kind of dialed in a little late, this is recorded. We will be posting it out and having a replay. So just follow up with George Roddy or me, or just flipthatcontract.com. We're definitely going to have information there. I would like to personally thank Brian Dunkman for at a very short notice. I called you Friday, Brian. Very short notice, researching this bill for us and giving us your professional opinion on it. And like you've said, this is your opinion. This is not you're not the Attorney General. Last time I checked.
That's right. And
So,
I'd like to thank Trent Thomas for being willing to take the time today to walk through the statute with me today as the Chief of Staff of Representative Darby.
yeah, that's oh wait, there's always one question snuck in at the end. Let's see, applause, applause, applause. Great as usual, Brian. So George, what do you got? Let's wrap this up.
Yeah. No, hey, Brian, thanks so much for doing this. You know, it really, we kind of thought this was the intent, but it's great to have your professional opinion and, you know, taking the time to research this. I think this really kind of clears the air and it gives us some comfort. I mean, it gives us the comfort that we thought. So, you know, I guess the last thing is, you know, for those that are still on the call, we've got Flip That Contract product launch is going to start in a couple of days. We want all of you guys, we're all about doing this the right way and making sure that each step is done correctly, professionally, ethically. We're not proponents of the get rich quick and let's, you know, and I think Brian, you know, your resume shows that you're in this thing for the long haul as well as we are. So I appreciate you taking the time. For all of you guys that want to learn exactly how Tim, Brian, myself, we invest, you know, I would just strongly recommend that you guys look at Flip That Contract and how we can try to build your bank account, you know, over the next 6 weeks. So anyway.
Gaynell Birch just asked a question. Said, and I got to touch on this. It says, why do we find out about this stuff after the fact? Why aren't we in front of it? We as real estate investors, the bottom line is we're cheap. And we don't want to pay for anything. We don't want to pay for education, advice, or help or support as an industry in a whole. And in my 10 years of doing this business, I've seen various different organizations and entities surface with the utmost intent and integrity about protecting the industry. But at the end of the day, it takes money. Everyone can't just volunteer, because at the end of the day, the lobbyist in Austin that we would need to hire isn't going to volunteer with us. So if you are interested in finding a way to influence legislation, step one is to vote, and step two is to get to know, be on the email list for whoever your representative or state senator is, and step three is to be active in a local investment club or active in a local political action group that tracks legislation. There is not a state organization that is actively protecting real estate investors. Unfortunately, that's just the way it is. And to the next question, yes, the slides will be reposted. If you registered for this, you will get a notification of how to access the slides and the audio and how to listen to it. And Brian, the effective date of this bill is September 1st?
Well, actually, since it passed by more than 2/3, it's immediately effective. But there's some, if you were trying to comply with the statute with respect to an existing private transfer fee, you have to give various disclosures, and I didn't go into that because that's not really the issue that we were called upon. But as far as this statute's effectiveness, yeah, it's effective immediately, and that means that future transfer fees would be void, and up to $250,000 fine. And I note that there's not a rulemaking authority that is given the authority to flesh out this statute in some other way. It's enforceable by, it is a Deceptive Trade Practices Act if it's violated, and that means that there could be customers or parties, private parties, that would assert a legal remedy under the Deceptive Trade Practices Act, and the state attorney general can certainly enforce it, but there's not some other private rulemaking authority out there that's going to further flesh out this statute.
Okay. Wow, I'm not used to being done so far in advance. Oh, here we go. What disclosure will be needed when we assign the contract? Brian, is there any additional disclosures or addendums that would be needed to assign a contract, in your opinion, after reading this bill?
If you wanted to be particularly careful, I suppose you could draft an assignment clause that if you created your contract as the wholesaler to limit the remedy of the seller and thereby created an option, then you could draft an assignment provision that would say, I agree not to exercise my option, and I agree that and the consideration for my agreement not to exercise my option is the payment that you're making to me. That would make it more clearly fall under the option exception language that I was referring to earlier. But I don't think it's necessary. It's not the purpose of the statute to prevent a one-time charge of a transfer of an interest in real estate. So I just don't think it's necessary. But if you, in an abundance of caution, if you were looking for a second way to step around the issue, you could draft the language that would make it appear to be consideration paid to the holder of the option to purchase the interest in property and release or not exercise the option. But I don't think that's really what's being covered by this statute. I don't think it's really necessary.
And Brian, if someone listening wanted to do something like that, they would just need to contact you and come sit down with you and really just go over what it is they're trying to get done, and then basically modify it and assign the contract.
That's exactly right. And I regularly think that wholesalers don't pay enough attention to the assignment language of their contract, and they don't pay enough attention to the actual assignment of their contract. And but there are ways to limit your liability as the wholesaler, so that if the contract is assumed by your assignee, that you will be released of personal liability vis-a-vis the seller. I think that's a smart provision to have in every contract. And at the same time, I think it's very, very shrewd to have an assignment contract, if you will, that not only gets you paid but protects you when you assign that contract. You make sure that your assignee formally assumes the obligations under the contract, and that you're going to be no longer on the hook for performing that contract.
All right. Tim, any other questions?
I think I'm great. Brian, I just want to say thank you for doing this on such short notice.
You're welcome. Hopefully I've answered everybody's questions. If not, they can send me an email or otherwise discuss the issues. Now, there'll be lots of open forums, I'm sure, going forward. I'll be anxious to see if there are carefully if there are lawyers out there who disagree with my analysis, and if so, I'll be glad to debate the issue.
Well, and I've never met an attorney that wouldn't be. Okay, let's see, Brian. Oh goodness. Are you recommending that we would have disclosures or not regarding this piece of legislation? Brian's recommendation was no.
Well, I don't think they're necessary. There are disclosures that will have to be provided if you're going to be charging fees to subsequent owners down the road, but that's what this statute was intended to address. But if you're just having a contract where you're buying a piece of property and you wish to assign that contract and get paid one time for it, I don't think you need disclosures.
Okay. Well, enough false starts. I think we're done. Brian, I appreciate it. I'm going to go ahead and stop the recording. We'll post this out there. Brian, I'll send you a copy. Everybody listening, Brian's contact information is right on the screen. Brian Dunklin, TexasRealEstateLaw.net, or you can email Brian at texaslaw@email.com. Brian's direct number is 972-863-3348. And if you ever need any help wholesaling real estate, check out Tim Harridge and George Roddy at flipthatcontract.com. We've got a 6-week wholesale real estate course that starts July 11th. Appreciate everyone coming, and we'll see you down the road.